Hello, my name is Eric Willison. I'm an attorney practicing law in the state of Ohio. Been practicing since 1996, and much of my practice has been in the area of landlord-tenant law, doing evictions for landlords and fighting evictions for tenants. So I've seen it from both sides, and I know both of the arguments. Word of introduction, what I'm telling you is about the law in the state of Ohio only. Other states may have similar or different laws. I wouldn't know, because right now I'm only certified to practice in Ohio, and that's all I'm going to be talking about today. Secondly, I'm a lawyer, but I'm not your lawyer. I don't know you, I've never met you, and I don't know the facts of your case. So to treat this as legal advice would not be a wise choice. But it is a wise choice to try to learn from what I'm saying so that you can better understand your situation. And if you do decide to go get a lawyer, maybe you'll be wasting a lot less of your time and your lawyer's time zeroing in on the issues and the facts. Okay, now in a previous video we talked about the three different types of arguments that a tenant may pose at an eviction hearing to defend it, which would be a merits argument, a procedural argument, a legal argument, or a procedural argument. Now I'm going to talk about another, again, I'm not going to get into specifics yet. I'm going to talk a little bit about sort of the meta aspects of arguing in front of a court and how it all works. A lot of people look at the law and they sort of look at it as a light switch. Either the light is on or the light is off. Either the guy is guilty or the guy is innocent. Either the case is granted, the eviction is granted, or it's dismissed. And along with those things, they look at it from a point of view of, if the facts are this, then I win. If the facts are that, then the other guy wins. And the trouble is that it's a lot murkier than that. And I'm going to give you a lot of why it's murky so that you can understand when to push things and maybe when to back off. Okay? So, the first thing, there's an old saying among trial lawyers that a good lawyer knows the law and a great lawyer knows the judge. Now, I'm not talking about, oh, I know the judge, I play golf with him, he's going to rule in my favor because we went to law school together. That's not the kind of knowing the judge that I'm talking about, although I'm sure that does happen sometimes. And it's a factor to think about too. But what I'm talking about is knowing you've been in front of that judge a lot as a lawyer, and you know what that judge likes and what that judge doesn't like. And here comes my landlord, or here comes my tenant, and my landlord or my tenant just has this attitude. And I've been in front of Judge Smith before 100 times, and I see this attitude trotted out in front of Judge Smith, and Judge Smith loves it. Judge Smith, he or she is going to rule in favor of my landlord or tenant just because this is the sort of person or argument that they like. Or the exact obverse could be true, that the judge doesn't like this kind of thing. Judge doesn't like it when the tenants come in and make this argument, or the landlord comes in and makes that argument. And normally that might be a winning argument, but the judge doesn't like it. And the judge is going to find ways to maybe not give the landlord what he or she wants, or not give the tenant what he or she wants because they don't like that aspect of it. So that is the first thing to think about when you're doing an argument in front of a landlord, in front of a judge. The decision maker, do you know that decision maker? Do you know the likes and dislikes? And as a pro se plaintiff, someone representing himself or herself, you're probably not going to know that. So that's why you want to get a lawyer who's been around for a while and practices a lot in front of this judge, and doesn't have a whole lot of hair, or if he does have a whole lot of hair, or she has a whole lot of hair, it's gray, and they kind of know what's going on with that judge. So, another thing is fairness. Maybe a judge doesn't dislike or doesn't like a client or a certain type of client. They're pretty even keel. Some guy comes in, he's a jerk, but you know what? They'll still give him a fair ruling. Somebody comes in, they're a very, very nice person, but hey, you're just going to get a fair ruling out of this judge. But what is that fairness? Judges know that the law is not always fair, okay? If the speed limit is 55 and you get stopped for doing 56, technically that's a violation of the law. Now, a lot of judges, they just don't see that as fair. And so they may choose to believe that the police officer misread the speed gun or whatever. There could be a lot of ways why you could do this. But in landlord-tenant law, if the tenant has a very, very weak argument, but the landlord is acting in a very unfair manner that brought this whole eviction to here in the first place, the court may say, I'm going to go with the tenant because, even though it's sort of a tough argument, I can see it, and that's good enough for me, and I'm going to overrule the eviction and dismiss it. Or, the same thing could happen the other way. Tenant could come in and has got a really, really good argument for why he didn't pay the rent from a legal point of view, but the court just thinks, well, I know you didn't legally have to do this right on that day or this, that, or the other, but that's what a good, decent person would have done. They would have just done that, and then you come in here and hiring these lawyers and trying to string this out and all that. You know what? It's not fair to the landlord. I know the law's on your side, but there is a way that I can rule against you. And here it is. And then bang, you're done. Okay? So whether the law is on your side or the facts are on your side, there's some aspects that go beyond that you need to think about. And I guess if you go back to the old Kenny Rogers song, the one he's most famous for, it was called The Gambler, he said it best. He said, every hand's a winner and every hand's a loser. And you're not really going to know which ones are which until everybody lays down their cards. But if somebody's bluffing, you may not ever even get to see the other guy's cards. You see? So it's not this sort of a if-then computer program that determines what is and what is not the law and who's going to win and who's not going to win. Everything is a little bit of a gamble. And to bring a movie citation into it, at the end of the movie Star Wars, the assistant comes up to the character who's the head of the Death Star, I believe his name was Grand Moff Tarkin, and he says to Tarkin, we've analyzed their battle plans, and there is a danger. Should we evacuate? And he says, evacuate in our moment of triumph? You overestimate their chances. Well, of course, maybe they had little chance to win, but they won. And so if a tenant comes in with a weak argument, and you think, well, gee, I can kick that one right out of the park, well, maybe. Maybe you can, maybe you can't. And your goal as a landlord, and your goal as a tenant, you need to stop thinking of it in terms of my goal is winning this eviction or my goal is getting this eviction tossed out. The goal has got to be, what result can I live with, even if it's not everything I want, and how do I get there? So if a tenant has a weak argument and all he wants is an extra week and a half in the place, then maybe it might not be a bad idea to do an agreed entry where he agrees to waive his argument if you will give him until the end of the month. You're still getting what you want. Maybe it's a few days late, but it's not about just, no, I'm going to win, I'm going to, push your nose into it. Judge may not go for that. So it's very difficult to know who's going to win and who's not going to win, no matter what the facts are, what the law is. You're basically playing on the percentages. But those long shot horses come in. So you gotta be careful. Look for the result that you can live with and then get out of there. Leave you with this last word. A judge once said to the parties, a very wise judge once said to the parties, look, I want you guys to go out into the hall and try to negotiate this case. Because right now, while you're negotiating, you guys have all the power. You guys get to determine what happens in this case. Once you come back in here and say, we can't work it out, Your Honor, we need you, at that point, your power is gone. And it's all mine. And I'm going to decide this case. And one of you isn't going to like it. And I don't know which one that is. Those are good, hard words. And they should be thought about whenever you're negotiating and thinking about how do I get to the result that I want.